Well, good evening. It's been a long day. I don't plan to have a lengthy discussion here, but there are some important messages that I would have said no matter what the verdict was tonight. First, we all owe a debt of gratitude to the jurors for their service and dedication. They worked hard. Our justice system is not always perfect, but it's the best the world has to offer. And much of the credit for that belongs to citizens who sacrificed to serve as jurors. And our justice system would not work without their service. Second, we all need to keep this case in proper perspective, and I hope that all viewers, readers, listeners will pay attention to this. Some have sought to make this about a larger political battle. While this case is serious for all involved, it is ultimately about a single day, a single bad day in a public courthouse. The defendant is certainly not evil, nor is she a martyr for some greater cause. It was a criminal case like many that make their way through this courthouse every day, and we all must accept the verdict peacefully. The third thing that I would have said either way, although the majority of the work on this case took place prior to my appointment, I have witnessed the incredible hard work and extraordinary talent of the team here that put the final pieces of this case together over the last month. I'm immensely proud to be part of that team. The team was led by First Assistant U.S. Attorney Richard Folling, Criminal Division Chief Keith Alexander, and Deputy Criminal Division Chief Kelly Watzka. Those three worked tirelessly 7 days a week for several weeks now to prepare the presentation of this case, and based on my years of experience, it was tried masterfully. Of course, the team was larger than those three assistant U.S. attorneys who appeared in court. Many other attorneys, law enforcement investigators, and litigation support staff also worked long hours to put this together. On behalf of the people of the United States that we serve, I thank all of them for their diligent efforts. I reiterate that all of us need to keep this case in proper perspective and peacefully accept the verdict. This is a serious matter for which the United States government found it necessary to seek to hold the defendant accountable. Experience and common sense, as well as the evidence presented in this case, demonstrate that the safest place to execute an arrest warrant is within a public area of a courthouse, such as the Milwaukee County Courthouse, that is security screening to ensure that none who enter, except law enforcement, are armed. That's why the federal agents sought, as law enforcement does every day, to utilize that safer environment to accomplish this arrest. But the defendant's actions provided an opportunity for a wanted subject to flee outside that safe courthouse environment, which led to a dangerous foot chase through automobile traffic and eventually to an agent taking the subject to the ground, which is always hazardous for both the officer and the suspect. There was certainly potential for many other dangers as well. Thankfully, no one was injured in that apprehension. Law enforcement work is fraught with dangers, and our law enforcement officers put their lives on the line every day. Here, they were carrying out their sworn responsibility to execute an arrest warrant. When they perform their duties, they should reasonably be entitled to do so in the safest possible conditions. When someone, especially a sworn public official, puts them in unnecessary danger by obstructing those efforts to make an arrest as safely as possible, they must be held accountable. The defendant exercised her constitutional right to put the government to its proof. We met that burden, and the jury has found the defendant guilty. It will now be up to the judge to determine what are the appropriate consequences. We'll have more to say about the circumstances relating to the case at the sentencing hearing. I can take a few questions tonight.
What do you think this split verdict says to the community?
Well, it was two different charges. The jury had to consider two different sets of elements. They worked hard. They concluded as to one, the defendant was not guilty, that we didn't meet our burden of proof. As to the other, we did. That it happens with some regularity in the court system.
Hey Brad, did anyone get offers of immunity in this case, any of the witnesses?
Not that I'm aware of.
What will the government be asking for when it comes to sentencing?
Those were a little far off from those determinations. You may have heard the judge set a briefing schedule relating to judgments on the verdicts. And once that's through, there will be a pre-sentence investigation report that's filed. We'll make all those determinations once we have all of the information we should have before that.
Could you just repeat what the jury ruled on which count and what the exposure is for Judge Dugan on maximum penalties?
I don't have that in front of me. The jury acquitted Judge Dugan on the misdemeanor count. They found her guilty on the felony count. I don't remember what the exposure is. Sorry.
Brad, you have a lot of experience working in state courts as a former prosecutor and district attorney. What do you think this verdict will do? What message does it send to other county courthouses about what potentially will happen in the future?
You know, I'd like to think that although until trial the defendant had maintained her innocence, I'd like to think that she looked back on this from the get-go with some regrets about what she did that day. She certainly did seem to, in those communications in the days following, where she had conceded that she was in the doghouse with the chief judge, I think she recognized this wasn't the right way to do things. I understand the concerns that Chief Judge Ashley expressed in that press release that became part of the evidence here. However, law enforcement is going to execute arrest warrants. And frankly, in most cases, the arrest warrants are issued by a judge. Law enforcement should be entitled to identify the safest place to do that. And a circuit court building that has a metal detector and security check-in at the front door is among the safest places we can find. I heard suggestions during the trial, well, why didn't they do a traffic stop? Traffic stops are inherently dangerous. You've all reported on the news of traffic stops that turn into dangerous chases where citizens and police officers sometimes get killed or hurt. That's not a safer way to do it. This was the safest way to do it. Like I said, I understand the concerns that Chief Judge Ashley expressed, but in the end, this is a way to do it that is safer for everyone.
There's been discussions recently about this case, the outcome having impacts on judges across the country, what they are or not able to do in their own courtrooms. What are your comments on people who may be concerned coast to coast?
Well, there was an important distinction made in the draft policy from Chief Judge Ashley and in the evidence in this case. This wasn't something that happened within the judge's courtroom. It was in the public hallways. Frankly, in my time as a judge in Waukesha County, we had a similar request of law enforcement that if you were there to execute an arrest warrant, that you let us call the case first. Let's get through this so that we know what's going to happen next. We don't unnecessarily, as the sergeant from the Sheriff's Department testified, you don't unnecessarily issue an arrest warrant for someone who didn't show up because law enforcement stopped them before they got in. That all makes perfect sense. Do it in the hallway.